and his brother justices, his brother pro-Wike justices. I want them to know before I read my speech that all the interim order, interlocutory order they've made against the Rivers State Independent Electoral Commission are worthless sheet of paper. They lack jurisdiction to make any order that restrain Rivers State Independent Electoral Commission or any agency of Rivers State government. Federal High Court is not a court of general jurisdiction. Federal High Court is a court of special jurisdiction. And under Section 251 of the 1999 Constitution of the Federal Republic of Nigeria, Federal High Court has jurisdiction to exercise one in the following cases. It says, Section 251, subsection 1, P, Q, and R. Let me read it out. Notwithstanding anything to the contrary contained in this Constitution, and in addition to any such other jurisdiction as may be conferred upon it by an act of the National Assembly, the Federal High Court shall have and exercise jurisdiction to the exclusion of any other courts in civil cases and matters relating to P. Administration and management and control of the federal government and any of its agencies. Rivers State Independent Electoral Commission is not an agency of the federal government of Nigeria. It's an agency of the Rivers State government. And therefore, Federal High Court cannot make an injunctive order to restrain Rivers State Independent Electoral Commission from conducting local government election. It's an agency of Rivers State government, not an agency of the federal government. Section 251, subsection 1Q says, subject to the provision of this Constitution, the operation and interpretation of this Constitution, insofar as it affects federal government or any of its agencies. What Justice Lufu and his pro-Wike justices of the Federal High Court are doing are what we call judicial abracadabra. The orders they have made has nothing to do with the management and control of the federal government or any of its agencies. What is at stake is the constitutional role of the Rivers State Independent Electoral Commission to conduct local government election as they are empowered by paragraph 4 of part 2 of the third schedule of the 1999 Constitution. I will come back there. Section 251, subsection 1Q, then subsection 1R, say, any action or proceeding for the declaration or injunction affecting the validity or of any executive or administrative action or decision of the federal government or any of its agencies. So the administrative action and decision of the Rivers State Independent Electoral Commission to conduct local government election in compliance with the Supreme Court landmark and very laudable Supreme Court judgment that mandates that all our local governments in Nigeria must be democratically elected. So the administrative decision of the Rivers State Independent Electoral Commission is not an administrative decision that affects the federal government of Nigeria or any of its agencies. So the order made by Honorable Justice Lufu cannot even be given by a law student that is still in the Nigerian law school. That order is a worthless sheet of paper. His court lacks jurisdiction to make any such orders against the Rivers State Independent Electoral Commission. The State Independent Electoral Commissions are state statutory executive bodies established in Section 197 of the 1999 Constitution, and the Constitution grants them autonomy. The Constitution established them in Section 197 as state executive bodies, and their composition and powers are as contained in paragraph 3 and 4 of part 2 of the third schedule to the 1999 Constitution. So, therefore, State Independent Electoral Commission is an agency that is within the statutory jurisdiction of the Rivers State House of Assembly. And it is only the Rivers State High Court that can make an order to restrain the Rivers State High Court from conducting local government election. Now, both Rivers State High Court and the Federal High Court are courts of coordinate jurisdiction. Therefore, we, as lawyers in defense of democracy, we commend the Rivers State Judiciary, for the bravery, particularly the Court of Honorable Justice IPC Igwe for upholding the rule of law and enforcing the judgment of the Supreme Court of Nigeria, which ordered that local governments in Nigeria must be democratically elected. The judgment of Honorable Justice IPC Igwe is in line with Section 287 of the 1999 Constitution, which mandates that the decision of the Supreme Court of Nigeria shall be enforced in any part of the Federation and by all authorities and persons and by all courts. Let the Chief Judge of the Federal High Court hear it very well. Section 287 of the 1999 Constitution. It says the decision of the Supreme Court of Nigeria must be enforced by all courts with subordinate jurisdiction to that of the Supreme Court. Now, in the Supreme Court decision that mandates democratically elected local government councils, the Apex Court specifically made the following order, order number 14, and that was the last order in that landmark judgment, that we must commend the Honorable Attorney General of the Federation for instituting this suit that aims at restoring democracy at the grassroots, which will stabilize democracy at the grassroots, increase the economy at the grassroots level, and fight corruption and insurgency. By the time youths are empowered by the various local governments, the issue of corruption, the issue of insecurity will be brought to the barest minimum. We are commending the Attorney General of the Federation and President Bola Ahmed Tinubu for initiating this fight for democratically elected local government councils at all levels in the Federation. Now we ask, the Supreme Court made order number 14 in that landmark judgment. The Supreme Court specifically said, an order is hereby made, an order of immediate compliance. The Supreme Court of Nigeria said, an order of immediate compliance by all states through its agencies, as in River State, through River State Independent Electoral Commission, which is an agency of River State government, not agency of federal government. That's what the Supreme Court is saying. That an order by all states through agencies to comply with these judgments and through their elected public official, that they should comply with the terms of this judgment and the orders made in this suit, and not just the present government of River State led by Fubara and all other successive government. That is the order of the Supreme Court of Nigeria. He made an order to states and their agencies like River State Independent Electoral Commission that they should comply with the terms of the judgment, and that is what the River State Independent Electoral Commission is doing, obeying the decision of the Supreme Court. Whereas, now, let us go further. Now, in the above order made by the Supreme Court of Nigeria, in line with the above order made by the Supreme Court of Nigeria, the River State Independent Electoral Commission is one of those executive bodies that is created in Section 197, as I have said earlier in the Constitution, and they are complying with the decision of the Supreme Court. Whereas the Chief Judge of the Federal High Court and his team of Wike lawyers are sitting on appeal against the judgment of the Supreme Court of Nigeria. And that is why the NJC must step in as quickly as possible so that our democracy will not crush. So that this democracy that we fought hard for, particularly President Bola Ahmed Tinubu, is one of those elderly statesmen that fought for the enthronement of this democracy. And we are saying that this democracy must not crush in the hands of Honorable Justice John Shaw of the Federal High Court of Nigeria. So we are saying that in line with the decision of the Supreme Court of Nigeria, the River State government and the River State Independent Electoral Commission, which is the government and the agency, as the Supreme Court specifically ordered, they are complying. Whereas Wike lawmakers are now using the Supreme Court, are now using the court of the Federal High Court to sit on appeal on the decision of the Supreme Court and specific order made by the Supreme Court that state governments and their agencies like State Independent Electoral Commission should comply with the terms of the judgment. And it is not only the action of the Chief Judge of the Federal High Court and his pro-Wike judges are not just tantamount to sitting on appeal to the decision of the Supreme Court, they are also violating the express provision of the Constitution that mandates that that the decision of the Supreme Court shall be enforced. I mean, Section 287 of the 1999 Constitution that mandates that the decision of the Supreme Court shall be enforced by all courts with subordinate jurisdiction. Now, I ask boldly, I ask the Honorable, the Chief Judge of the Federal High Court, are you now telling the Supreme Court of Nigeria that the Federal High Court is not a subordinate court to the Supreme Court of Nigeria? If that is what the Honorable Justice Elifiu and his other pro-Wike judges of the Federal High Court are doing, let the NJC wade in and tell us whether or not the Federal High Court is not a subordinate court of record to the Supreme Court of Nigeria, and whether or not they are bound or they are constitutionally bound under Section 287 of the 1999 Constitution to enforce the decision of the Supreme Court of Nigeria. So we, as lawyers in defense of democracy, are calling on the Rivers State Independent Electoral Commission to go ahead with your election, relying on the landmark decision of the Supreme Court of Nigeria, which the Rivers State government and the Rivers State Independent Electoral Commission is complying in line with the 14th order made in that judgment by the Supreme Court. The 14th order made by the Supreme Court that says that the state government and the agencies should comply. You're already complying. You are on the right track. Go ahead with your election. In addition, the ruling or the judgment of Honorable Justice IPC Igwe of the Rivers State High Court has validly implemented, enforce the decision of the Supreme Court in line with Section 287 of the 1999 Constitution. The High Court of Rivers State, in this landmark ruling by Honorable Justice IPC Igwe, have enforced the decision of the Supreme Court. So based on this legal standing, the Rivers State Independent Electoral Commission should go ahead and boldly and proudly conduct their election come Saturday, the 5th of October, 2024, relying on the judgments I have referred to and relying on the judgment of the Rivers State High Court that have now enforced the decision of the Supreme Court of Nigeria. And it is the Rivers State High Court that has competent jurisdiction to make an injunctive order against the Rivers State Independent Electoral Commission, like I have read out in Section 251, subsection 1, pure QR. It is only when it has to do with agencies of the federal government or interpreting the Constitution as it concerns the federal government that the Federal High Court has jurisdiction. The Federal High Court does not have general jurisdiction. The Honorable Justice Liviu, you should know. Even a law student at the law school should know that the Federal High Court does not have general jurisdiction. So you don't confuse the jurisdiction of the Federal High Court in the matter of whether or not the members of the Rivers State House of Assembly, they are still valid members. They can seek interpretation at the Federal High Court because their election is conducted by INEC. INEC is an agency of the federal government of Nigeria, and the Federal High Court can make an injunctive order or make an order of mandamus or any compelling order against INEC to either conduct by-election into the Rivers State House of Assembly or not. Within that context, the Federal High Court has jurisdiction. But once it shifts to making an injunctive order against a state agency, Rivers State Independent Electoral Commission, Section 251, subsection 1, QR, denied the Federal High Court of jurisdiction. And all the orders made with respect to the conduct of local government election in Rivers State on Saturday by Rivers State Independent Electoral Commission, any order made by the Federal High Court is a worthless sheet of paper. I would be very glad to face any number of galaxy of Senior Advocate of Nigeria on appeal on that decision at the Court of Appeal and at the Supreme Court. Let us know whether the provision of Section 251, subsection 1, PQR, has been expunged from our Constitution. Conclusively, we, As lawyers in defense of democracy and human rights, we are keenly watching the development in River State political saga. And we're also watching how the interests of one man, the former governor of River State, Chief Wike, would now crash the whole institutions of government. Because there is Wike, who is omnipotent, omnipowerful, omnipresent. If there is Wike, who is now the demigod, or maybe we should be going to church on Sundays to worship Wike, put his picture in the sanctuary and begin to worship Wike in River State as God of River State. If that is what Wike has assumed himself to be, and he's getting backing of the Federal High Court, we are, as lawyers in defense of democracy, telling Wike that he doesn't have such powers. Institutions of government, in a democratic government, institutions are very strong. There is what we call rule of law. Whether or not you think the rule of law is on paper, it cannot be implemented, or rule of law can be bent when it has to do with prominent, big politician or somebody that have now assumed himself to be God, and then because of him, rule of law will be turned upside down. We are saying that this democracy will sustain it together in this country. No matter what anybody thinks he is, no matter how many million, how many billion you get, we don't have such. We have our constitutional right within the ambits of the law, within Section 39, to freely express dismay, displeasure against corruption, against injustice, against oppression. We have our right under Section 40 to gather as we have gathered now as coalition of organizations in defense of the truth and in defense of democracy in River State. That remains the law, and we are telling the Chief Judge of the Federal High Court that he cannot turn the Federal High Court to a mere agency of Nyesom Wike. Maybe we should now rename the Federal High Court to Nyesom Wike Federal High Court. If that is what Honorable Justice John Soho wants Nigerians to believe, from today, maybe we'll begin to call the Federal High Court Nyesom Wike Federal High Court. And we are saying that lawyers in defense of democracy will continue to speak the truth, will continue to defend democracy, we must continue to defend the rule of law within the ambits of the law. Thank you so much.
Members of the oppositions are going to participate in that election. For our own interest is to continue to defend the rights of Nigerians to go to the poll without any form of intimidation, any form of harassment, either for the judiciary or from any arm. The local government system must be given all the necessary support, all the wherewithal to sustain our democracy. It's the system that is closer and closer to the grassroots to our people. What we are fighting for is multi-party democratic participation. The right to participation is fundamental in our constitution. The right to free and fair processes for election is also fundamental in our constitution. What we are struggling for is that federal agencies should not take over what belongs to the state. We are running a federating unit, a federation that has its own federating separations, that has all the rules and regulations on how we deal with ourselves. And we will further weaken the state if we want federal agencies like the Federal High Court led by John Tozo to continue to take decisions, and judges under the Federal High Court taking decisions that undermines our democratic development, our democratic projection. The 5th of October is the key point here. The River State Independent Electoral Commission, what Nigerians should know, that's why I used to tell a lot of Nigerians, what Nigerians should know, in independent elections in the state, they are not under in their National Independent Electoral Commission. They are a creation of the constitution of their own. They derive their power from the constitution. They share equal authority as INEC shares its own authority in the constitution, and they have the authority to be able to carry out their functions without any hindrance, any manipulations, or any intimidation from any quarters. What we are saying is that in defense of to save this democracy, we have come together from civil society groups, from political parties leaders, from ethnic nationalities, from lawyers in defense of democracy. We have come together to state this categorically, that Justice IBC Igwe judgment in High Court, River State High Court, has clearly stated that the elections will go on Saturday. And what we were urging is that these elections should go on unhindered, and these elections should go on without any sense of violence. Those who want to participate in the election should participate. If you have any other issue, you take it to the tribunal as it's set up. We must to fight continuously to make sure the temple of justice remained the temple of justice. Even in the worst period where our democracy was not there, every arm will be stopped by those who have hijacked our democracy, but the judicial system was never touched. Because the judiciary remained the last hope of the common man, where people can go and get justice. Local government election is a process by which people are going to get elected into office. We are not there yet. We are working on a lot of other things to make sure that government become a true representation of the people. But we cannot get there if we do not defend the right of those whose rights have been oppressed today. If we do not stand and speak on behalf of political party. If you listen to Martin Muller when he talked about when they come today and you are not standing, it might be your turn tomorrow. So for us to save this democracy, courageous men, determined people who are determined to make Nigeria work for our citizens, for our masses, must stand up in defense of this democracy. This democracy, we have invested our energy. People have died because of it. People are standing and losing their business and sacrificing to run elections and run presidential elections. And we must defend it to wait and see that this democracy is sustained and the history is left to be told by our unborn children. 5th October, we must state categorically that the judgment that was delivered by Justice Lifuya is actually, for me, is belated. Because one thing that is there is that there's a judgment already from a federal high court in Rivers State, state high court in Rivers State, and that judgment has already clearly stated that the election will go on. And that judgment stopping that the voter register should not be given to political parties. Yeah. Political parties severally, more than 4 APP have said it, PRP have said it, another party, coaliting parties who are part of our coalition, who are participating, are clearly stated they already have the voter register before that day, a week ago. About 2 weeks now, they have the voter register. So the voter register is already on ground that they will use to conduct the election. And the independence of State Independent Electoral Commission should not be compromised at any time. And because whatever we start in little way can offend the whole body of our elections. Because if you take police to go and block Rivers State Independent Electoral Commission, one day the federal government will come and say they are blocking the National Independent Electoral Commission. Because we must defend in little ways before we'll be able to defend our collective interest. Our interest is for justice to be served in the way that the law has stipulated it. It's for people's right to be respected. Our interest is also to tell you that Section 109, Section 1G, it clearly states that if you have declined from the seat where you are elected, you will vacate your seat. It's not something we have to wait for people to give any effect to, because nobody to even give effect to that provision of the law, because even the person that is supposed to at the camp and a new speaker is already there who have given all the necessary input to that case. So what we are saying today is that the election on the 5th of October is an election slated already in process. And we must save our democracy by allowing that election to come in place so that we will continue to build on our interest. It's multi-party democratic system in this country. If we allow people to suppress the views of the Nigerian people, to suppress to a point when we run into a situation of a one-party state, we all have ourselves to blame. As our interest is that every political party, the international committee, they must look at this, because political parties are critical vehicle for the establishment of good governance in the country. And especially opposition political parties are very important to make sure that democracy works for our people. Because if we avoid this process and we do not allow the check and balances that exist currently to continue to exist and even flourish and grow to a point that political party can have the right and the authority to hold government accountable to their promises, then we have failed as a people. So in lieu of that, and the refusal for us not to fail, is why people with conscience, people who are determined to safeguard this, even at the cost of their life, are saying that the Saturday elections is an election already in process. It's an election already in process. And even before the case starts, deliver very questionable judgment and have brought the name of the judiciary and particularly the Federal High Court, Abuja, to disrepute. The world, and especially indigenes as residents of Rivers State, no longer treat their words with the respect that pronouncements from the court ought to command, but see them only from the political prism and refer to them as political judges or, more particularly, as pro-Wike judges. Before we go further, we would like to commend the Rivers State Judiciary, particularly Justice IPC Igwe, in recent judgment mandating the Rivers State Independent Electoral Commission to conduct local government election on October 5th. It is a significant step towards upholding democratic principles in Rivers State. This decision aligns with the Supreme Court ruling that mandates all states to hold elections for local government area, chairmen and councillors within 3 months. It is crucial for democracy that this election take place without undue delay and interference. I think one of the key things that we must be able to explain is that there's nowhere all the time that we've been conducting elections, and because of the kind of elections that have ushered in leaders that have not shown any competence to deliver on our goods for our people, from 2007, 2006, 2007 election, you saw that there was a progression to not to have judgment stopping an election that is already in progress, or to have a judgment or an unexpected order stopping the primaries of a political party that is already in progress. This is to bring sanity to our electoral process. And whatever that is going contrary to that today is not something that any Nigerian should encourage. We commend Justice IPC Igwe because his judgment keeps the peace in Rivers State today. Rivers State is very important. The plan by the enemies of our country, working in high places to throw Rivers State into anarchy, has been effectively arrested by Justice IPC Igwe's judgment. However, we are deeply concerned about certain judges within the Federal High Court in Abuja. We believe that there has been a troubling trend of partisanship among some judges, particularly those presiding over cases related to Rivers State matters. It is time to salvage the integrity of the Federal High Court and the Nigerian judiciary most especially. They have turned the Federal High Court into the playground for pro-Wike groups, where we hereby call upon the National Judicial Council, NJC, to take immediate action by suspending John Toso, the Chief Judge of the Federal High Court, along with Justice Peter Lifu, Emeka Nwete, and Justice Omotocho. These judges' actions and decisions have raised serious questions about the impartiality and commitment to justice. The NJC should not keep quiet and wait for petition when they have been hearing the cries of different groups, citizens about what is happening in the Federal High Court. Furthermore, we urge the NJC to order a forensic audit of over 32 cases that the Justice Toso has explicitly assigned to these pro-Wike justices regarding Rivers State issues. The assignment of these cases raises concern about manifest bias and conflict of interest that could undermine public confidence in the judicial system. We believe these bias and pro-Wike judges must cease to be involved in river cases, and I do not know why it must be an interest to Nigerians. Because you can't have a case when a case concerning a particular state, every matter that has to do with that goes to particular judges. And these cases the judgment tends towards one interest. We must be able to continue to defend democracy in this country, or else we will all be in it. Most cases that involve Rivers State, their continued participation undermine public confidence in the judiciary and compromise the principle of impartiality, impartiality fundamental to our legal system. Therefore, we are calling for their compulsory retirement from the bench. We urge the newly elected president of the Nigerian Bar Association, Chief Afam Osigwe, SAN, and all members of the legal profession to take a stand against these infractions of the Federal High Court. The NBA must embody justice and integrity by vocally opposing these infractions. We propose that the NBA issue a directive encouraging lawyers to boycott any court case proceeding by Justice Peter Lifu, James Omotosho, and Emeka Nwete concerning Rivers State matters. These judges have aligned with specific political interests, which is unacceptable and is rejected as it stands. To illustrate our concerns, we like to draw attention to recent judgment made by Justice Peter Lifu. In the case involving APP, a member of the Coalition of United Political Party, versus INEC, 28 others in suit number FHC/ABJ/CS/978/2024. Justice Lifu on the 20th September 2024 ruled that the PDP National Legal Advisor cannot appoint legal representation for the PDP against the state chapter of the party, since all the facts connected to the case were concerning Rivers State alone. In that case, the judge also cited Justice Iyangeko's decision in suit number FCH/ABJ/CS/112/2023, wherein Justice Eko also held that the National Secretariat could not appoint representation for the state chapter. Justice Lifu further cited the decision of Justice E.A. Obili of the Federal High Court in Port Harcourt in suit number FCH/PH/CS/90/2024. On the same issue, he cited other judgments in the same line and concluded that this court cannot create a different channel of reasoning, different from the established precedent, as doing so will amount to judicial confusion, conflict of interest, judicial impotence, and judicial rascality. On 30th September 2024, in a suit filed by APC, the same judge, in his ruling to achieve his predetermined political agenda and objectives, held that the state chapter of the party is not a juristic person, and it is the National Legal Advisor of the APC that has the duty and the authority to appoint counsel to represent the APC, and the court does not have the jurisdiction to interfere in the internal affairs of political party. It therefore discontinues the process filed by the state chapter of the APC and upheld those filed by the National Legal. These are the issue of double standard. The problem, if you in a system that promote equality and respect for the representation of all human persons and association, we must be able to have one governing principles in our law that protect all and does not discriminate against another. In just 10 days, the same judge reached conflicting decisions on the same issue to achieve a pro-Wike interest, or is it that there is a different rule of court to decide the case of the APC matters and a different rule for other parties? Other political parties as established in Section 221 to Section 229 in the Constitution of the Federal Republic of Nigeria enjoy equal rights, equal representation, equal authority under the law. And any attempt to discriminate, to differentiate, and to reduce that separation will not be welcomed by members of the opposition. To Justice Lifu, the agenda is one, but the reasoning and conclusion may be different and even conflicting. Such inconsistency poorly reflects his judgment and raise questions about the impartiality and commitment to fair legal practices in Nigeria. Justice Lifu, in his judgment of 30th September, also purported to have directed the Independent National Electoral Commission, INEC, not to release voter register to Rivers State Independent Electoral Commission for the conduct of local government elections. We wonder why we, even as chairmen of political parties in Nigeria, have received most of the members of the coalition who are participating in the election, PRP, APP, have received the registered voter from INEC, which the drive is with us. The drive is with them. They have presented it to the public in Rivers State, and as a member of this, the members of this coalition, they have acknowledged the receipt from INEC. The Federal High Court by Justice Lifu wants to take us back by asking INEC not to release the voter register. How do you say they should not release the voter register that has been released? The voter register is already in the custody of political parties that are participating for the local government elections. APP had confirmed that in one of their rallies. PRP confirmed that they have the same voter register in their custody. So, in their custody. In light of this severe concern regarding judicial conduct, JUD will take further steps by writing petition to international bodies, including the United States, the United Kingdom, and European Union countries. We will advocate for visa ban against these politically biased judges and call for their names to be placed on international alert list. We must hold accountable those who compromise our democracy through their actions on the bench. In our petition, we will urge these countries to investigate the lifestyles of these judges and their family members abroad, especially their spending and investment in property, jewelry, and stocks. Given this, Judge Totu continue assignment of cases related to Rivers State cannot be justified. It is essential for the credibility of our judiciary that all judges operate without any semblance of partisanship or favoritism. Now we understand why so many people spoke against Justice Totu's appointment as the federal chief judge of the High Court. If only we had listened to these voices these days, maybe the country would have been saved from this embarrassment coming from the Federal High Court today. Nigeria will recall that sometimes last year, following his anti-party activity and calls to the PDP to take disciplinary action, Wike went to court and obtained an ex parte order to restrain the PDP from expelling him from the party. That was the end of that matter till today. Ex parte orders are now used to serve as final judgment in the case of the court matter. In January 2023, the then state chairman of the PDP, Dr. Desmond Akao, approached the Federal High Court, Abuja, and obtained an ex parte order to stop the PDP from dissolving the state ESCO. During the same period, the G5 governors, led by Wike, also approached the court to stop the PDP from disciplinary actions against them. Justice J. Motosho granted them all an ex parte order and later an interlocutory order, which ended the matter finally. On the 5th April 2024, Justice Inyako of the Federal High Court, Abuja, in an expected application by the third party, ordered that Prince Uche Secondus, Chief Celestine Omeha, Honorable Austin Okpara be stopped from attending PDP NEC meetings. They were stopped then. Notably, these politically motivated and absurd rulings have been overturned by the Court of Appeal, which held that the Federal High Court acted outside its jurisdiction and ought not to have entertained the matter in the first place. Sometimes in December last year, the Southeast Zonal Executive Committee of the PDP sacked the National Secretary of the PDP, Senator Samuel Anyanwu, Sam Dadi, and replaced him with another person. Senator Anyanwu, a confessed Wike ally, had dragged the party to the Federal High Court, Abuja, and obtained an ex parte order restraining the PDP. The Supreme Court has ruled that such leadership issues are internal affairs of political party. Yet the Federal High Court imposed him on the party. Local government chairman in Rivers State, elected in the administration of Wike just before their tenure legitimately ended, filed a suit against the governor of Rivers State at the Federal High Court, Abuja, to indirectly extend their statutory tenure. Justice James Omotosho granted their ex parte application and ordered maintenance of the status quo pending the determination of the suit. In another suit, Justice James Omotosho, under funny circumstances, nullified the Rivers State budget, a budget of a state that is a question of a constitutional matter, was nullified. Ordered the Inspector General of Police to continue to provide police protection and recognition to the former lawmakers that have decamped, if you look at Section 109, Section 19G. Declared one bright Emewule as Speaker, even when he is no longer a member of the State House of Assembly. Restrained Governor Fubara from withholding any amount of money due to the House of Assembly. Restrained the House of Representatives for taking any legislative function of the Rivers State House Assembly, a constitutional matter also, even when there was no move to do that. Nullify redeployment of civil servants in Rivers State. State by the Rivers State Head of Service. Indicted Governor Fubara for the burning of the Rivers State House of Assembly complex without any proper investigation. And also barred the Rivers State government from rebuilding the complex, among others, in whose interest that the House remained in the state that it currently is. In an ex parte application, Justice Peter Lifu on 24th September granted an order restraining the PDP from dissolving the pro-Wike-led faction of the party in the state or appointing any caretaker committee. This was just a few days before the September 30th judgment, in which he purported to have stopped the election because this pro-Wike group had also declared that the party will not participate. Justice Lifu also knew that Justice Ambo Subere of the Rivers State High Court has restrained PDP from proceeding with congresses in Rivers State. He, however, overruled Justice Hambo and without jurisdiction and order that the federal congresses should be conducted. Justice Lifu has, for the second time, overruled a court of coordinate jurisdiction just for political expediency. On September 20th, Justice Lifu strangely declared that a suit seeking to direct INEC to conduct elections in the 27 vacant seat in the Rivers State House of Assembly was a pre-election matter and was therefore filed out of time. This is a ridiculous reason to achieve a predetermined end because the campaign happens after election. So I don't know how it will now become a pre-election matter. Nigerians have not forgotten as so soon. Better put, the Nigerians still remember with ignominy the decision of an enemy of democracy, Justice Bassey Ekpeme, who on June 10, 1993, and in a similar fashion as we see today, delivered the order that truncated democracy in Nigeria and led to the nullifying of the 1993 presidential election. The president will remember very well that following these consequences of that order, he had to flee into exile for the military to take over. The president should, therefore, be the last person to allow political judges anywhere on the bench. Nigeria also remember another enemy of democracy, Justice Wilson Igbo, whose several politically motivated judicial pronouncements almost torpedoed our democracy before NJC took action. How long must we wait again before Nigeria see NJC in action? Because of one man's over-bloated ambition and greed to maintain control over the treasury of Rivers State, we are allowing the destruction of an institution such as the Federal High Court. How can Justice Lifu, in an apparent political move, purport to have nullified Section 60, subsection 2 of the Rivers State Independent Electoral Commission law, which asked the jurisdiction of court to stop election, when a very similar provision in Section 84, subsection 15 of the Electoral Act is still there? If Nigerians allow this judgment to stand, will we cannot use it as precedent to stop a general election someday? Because if a court can stop an election that is already in progress, then Nigerians were running at risk if we allow courts to continue to stop election that is already in progress. President Bola Ahmed Tinubu and the APC keep quiet, thinking it is for their political benefit now. So all the road can continue. But when this serpent turns into a dragon tomorrow, they should not complain, no, because assuredly it will go round. In conclusion, we stand united in our call for accountability within our judicial system. The integrity of our court must be preserved if we are to maintain faith in democracy itself and reiterate our call for immediate action against these biased judges of the Federal High Court in Abuja. We all just stakeholders in Nigeria legal system to join us in safeguarding our democracy and act swiftly, decisively, so that justice can prevail without prejudice or favoritism. Thank you very much for your attention.
Congratulate Nigerians on the occasion of her 64th year anniversary of independence. Indeed, more than ever, we are united in our diverse ways. And it is this our unity in diversity that has kept Nigerians, despite the negative predictions and permutations of naysayers, Nigeria still remains indivisible. Having listened to the president's speech yesterday, it further strengthens our resolve as Nigerian youth and as ethnic youth leaders to continue to speak truth to power and to expose all the rot that is destroying the fabrics of our collective efforts as a nation for a better Nigeria. Remember, not too long ago, you all gave us listening ears when we spoke about the dangers and the mistrust in our banking sector, ranging from troubling concerns surrounding investors' funds, the negative outcomes, and the attendant effect it impacts on investors' confidence, to unwarranted, unexplained, irregular, unlawful, incessant, and exorbitant deductions of customers' funds, and the wholesome unethical banking practices that characterizes banks like the Guaranty Trust Bank, which declared a fictitious and questionable 1 trillion naira profit in the first quarter of the year 2024. When we know how Nigerians are suffering, we wonder where these profits are coming from. Again, we are calling on all Nigerians, both at home and in diaspora, to please leave whatever they are doing and listen to the text of this press conference, which we fully endorse on the systematic savagery, attacks, and destructions of democratic process in Nigeria, especially as it affects local governance, the only government that is closer to the people, despite the landmark judgment of the Supreme Court and the federal government's directives on constitutional democratic governance in all local government areas in Nigeria. We call into aid the well-thought-out plans to sabotage the Rivers State Local Government Council election, scheduled to hold on the 5th October 2024, and the series of attacks against the democratic process and how the courts have allowed itself to be used as a tool for these dangerous moves. Even though our aim at this press conference is to express our displeasures at the destructive aims of some Nigerians, using the instrumentality of our courts, judicial system, and worst of
is the fact that the courts, we mean the Federal High Court, has allowed itself to be used to stifle democratic processes in Nigeria. We must not, however, fail to thank those of our judges who stood their grounds in the face of blackmail and threats to do the right things. We as ethnic youth leaders wishes to express our satisfaction with the mandatory order of the Honorable Justice IPC Igwe made on the 4th September 2024, and the direction that there must be democratic process at all levels in all local government areas of Rivers State. That is, election must hold in Rivers State on the 5th October 2024, and there is no going back. We are at the grassroots with the people, and we understand the importance of constitutional democratic process. And as such, it becomes a marvel how the Federal High Court and some particular judges will allow themselves as a willing tool in the hands of politicians against the conduct of the Rivers State Local Government Council elections, scheduled to hold on the 5th of October 2024. Of what ultimate good will it be to the people of Rivers State if elections are not conducted and governance is denied the good people of Rivers State? It is on this note that we, the ethnic youth leaders, support the reading of the text of the press conference and beckons on all Nigerians to indulge us. I want to say that we fully endorse the press